newspaper and the Florida Policy Institute. Our third speaker tonight is another longtime environmental activist and attorney, Jennifer Scuteri. Jennifer is a member of the bar in both Florida and Massachusetts, and she has been a member of the League of Women Voters for the past 2 decades and served as vice president of her league chapter up north, where she also worked to advance legislation to implement LEED building currently recognized composting program. She was elected as the first woman town moderator in Hamilton, Massachusetts, where she resided over the legislative process. And here in Southwest Florida, Jennifer is active in environmental initiatives, particularly pertaining to water issues. She's also an advocate for voter protection and was active in the election recount here in Florida 2 years ago. I want to thank all of you for sharing your expertise and insights with us tonight. And with that, I'm going to turn things over to our first speaker, Ron Ellington. Ron?
Good evening. I want to talk with you about some history that is relevant and pertinent to our topic for discussion this night about the protection of voting rights. When the Constitution was initially adopted in 1787, the only people eligible to vote were white males who owned property. One of the enduring stories of the American experience has been the struggle for those left out of that original bargain to gain the right to vote, access to the ballot, and equal citizenship. These struggles have been met with strong opposition from those who have power and did not want to see their political clout reduced or shared with others. William Faulkner once said that the past isn't dead, it's not even past. And that's perhaps one of the themes of the topic for discussion tonight. Women received the right to vote 100 years ago in 1920, after decades of struggle, including going to jail and being abused, that ended in the ratification of the 19th Amendment. In 1971, 18-year-olds received the right to vote in the 26th Amendment. The country decided that if you were old enough to be drafted to fight in Vietnam, you were old enough to be able to vote. The struggle to secure the right to vote has not been easy. It's required persistent effort. I want to focus this evening, obviously, on the 15th Amendment, one of the 3 amendments adopted after the Civil War. The 15th Amendment provides in Section 1 that the right of citizens of the United States to vote should not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. Section 2 of the amendment gives Congress the power to enforce the amendment by appropriate legislation. The reaction in the South to the passage of the 15th Amendment that gave newly freed Blacks the right to vote was violent. It helped spur the rise of the Ku Klux Klan. Sadly, for nearly 90 years, the United States did next to nothing to secure this right, to enforce this constitutional right for Black citizens to vote. What were the conditions on the ground in the old Confederate states in the 1960s and 70s? Let me tell you about a civil rights hero. Fannie Lou Hamer was a Black woman. She was a sharecropper on a Mississippi plantation along with her husband. She learned in 1962 that the Constitution gave her the right to vote, and she went into town to seek to exercise that right to register to vote. She was turned away by the registrar because she could not produce receipts for the payment of poll taxes for the last 2 years. Parenthetically, the 24th Amendment to the Constitution in 1964 abolish poll taxes or other taxes as a condition on the right to vote. When Ms. Hamer returned to the farm, she was met by an angry owner who ordered her to leave immediately because she had dared to seek the right to vote. She lost her abode and she lost her livelihood because of her interest. She persisted and she tried to help other Black citizens to gain the right to vote. And she went back repeatedly herself to try to pass the tests that were required for people to vote in those days. She was threatened, she was shot at, she eventually was arrested and beaten with a blackjack in jail, but she persisted in trying to secure this important right. There were other less dramatic obstacles to voting than terroristic threats. One was the adoption of literacy tests in these states, where an applicant to register to vote would have to demonstrate that they could read and write English. Well, a majority of voting age Blacks in the South, as a result of segregated schools and poor education, were unable to read and write. And this had a significant suppression on their right to vote. Many white citizens at the same time were unable to read and write, but there was a fix for that, the grandfather bailout, in which if your grandfather was eligible to vote, you could vote without passing a literacy test. There were also tests that required that the applicant be able to explain and understand a provision of the state law. Now, white citizens were often asked questions like, what are the three branches of government? Or what does double jeopardy mean? Ms. Hamer was asked to explain the difference between de jure and de facto rules, something I, as a longtime law professor, might have difficulty doing. The final device was a good moral character requirement. The trick here was that you could only satisfy that requirement by having two current voters testify to your good moral character. And you can imagine that in small Southern towns, it was difficult to find white people that would risk community scorn by vouching for the good moral character of their neighbors. Congress, when confronted with these facts, decided that strong measures were necessary. They found that there was pervasive and systematic discrimination against Black citizens in exercising the right to vote. The measures that I described, the literacy tests, the read and understand and explain tests, had the intended effect. In Alabama, some 60% of white citizens were registered to vote as compared to 19% of Black citizens. Mississippi was the most extreme case. Nearly 70% of whites in Mississippi were registered to vote. 6.1% of Black citizens were registered to vote. Congress decided that these conditions required strong measures, and they passed the Voting Rights Act of 1965. Section 2 of the act prohibited a state from imposing a standard, a procedure, or policy that it would have the effect of denying citizens the right to vote because of race. The heart of the act, though, was Section 4 and Section 5. Section 4 is the so-called coverage provision. It provided that if a state had a test or device in place in the 1964 presidential election, and it had low voter turnout, less than 50% of the adults voting in that election, then it came under the Section 5 provisions of the Act. Section 5 didn't apply to all states, but thus just those states that had those tests and devices and low voter turnout. It was a pre-clearance procedure in which a state that was covered by Section 5 could not put into effect a change in its voting laws until it had submitted an application to a federal court in Washington, D.C., and shown that the purported change would not have the effect of discriminating or denying or abridging citizens' right on the count of race or color. And in that lawsuit, the state would have to bear the burden of proving with evidence that that would be the case. The case before the Supreme Court on the constitutionality of the 65 Voting Rights Act is called South Carolina against Kotzenbach. It was decided in 1966. The Supreme Court looked at the record that Congress had considered and concluded that extraordinary conditions justified extraordinary measures. Yes, this was a stringent response, but it was necessary because there was entrenched racial discrimination. There was enduring racial discrimination with ingenious devices calculated to deny the constitutional rights secured by the 15th Amendment. The Supreme Court upheld the constitutionality of the 1965 Act. That act had a 5-year sunset provision. It was renewed in 1970. It was renewed again in 1975. It was renewed yet again in 1982. The final time that it was renewed was in 2006. And that version of the act was challenged in a new lawsuit that reached the Supreme Court, a case called Shelby County, Alabama against Holder. And in this case, the Supreme Court, in a 5-4 decision written by Chief Justice Roberts, declared Section 4 of the Act unconstitutional. What changed? Well, according to the majority, history did not stand still in 1965. Conditions had changed from the time that Congress originally adopted the Voting Rights Act. Congress could not rely on old data from the 60s and the 70s to justify such a punitive measure. States are entitled to equal sovereignty, and the court said that a state could not be burdened by going hand in hand to Washington, D.C. to put a change in their voting laws into effect that a neighboring state not covered by the act would be able to do straight away. The Supreme Court pointed to the results in the 2000 and 2010 census that showed that now there was almost parity between blacks and whites in the percentage of voters. In Alabama, for example, they were almost equal. In Mississippi, the state that you remember that had the greatest disparity, now 75% of black citizens were registered to vote as compared to only 73% of white citizens. Chief Justice Roberts said, no one should doubt that the improvements that we see are attributable to the Voting Rights Act. Ironically, the very success of the Voting Rights Act caused its demise. In dissent, the late Justice Ruth Bader Ginsburg asked a salient question: what will happen now that the preventive, prohibitive effects of Section 4 and 5 are removed? Will states once again try to invent ingenious devices that would suppress voting by minority citizens? Let me give you a recent example to ponder. Last week, Greg Abbott, the governor of Texas, entered an order saying that Texas counties could have only a single box, secure box, where voters who wanted to turn in their mail ballots in person rather than trusting them to the post office could deposit their ballots. Now, Harris County is where the city of Houston is located. It has a population of some 4.5 million people. It stretches the size of the state of Rhode Island, but now it's limited to a single, secure, designated box where voters can turn in their ballots if they don't want to mail them back to the voting office. Ask yourself if you think that measure would have passed the stringent provisions in Section 4 and Section 5. Well, Congress responded to the Holder decision in 2019 when Democrats retook the House by passing the Voter Advancement Act of 2019. It sought to update the data on which the voting rights extension was based. It passed the House on nearly a strict party line vote, with one Republican joining all Democrats in favor. It has never been taken up by the United States Senate. Let's contrast that with what happened in 2006, the last time the act was reauthorized. It passed the House by a broad bipartisan coalition. It passed the Senate unanimously. It was signed into law by President George W. Bush. Sadly, the protection of voting rights has become a partisan political issue. And with that, I'll turn it back to you, John.
Thank you for that, Ron Ellington. We're now going to segue over to Howard Simon. And Howard, you have the floor.
So my talk is going to be really built on the shoulders of everything that you just heard from Professor Ellington. I'm going to be adding to it. What I want to start off with is the reinforcement of the message that you just got, which is that the right to vote was the heart and soul of the civil rights movement. This has been a battle about political power. Martin Luther King said that the history of voting rights in the United States is in large part the history of white people in power devising endless ways to keep Black people from casting a ballot. This has been a battle since the founding of our country, as Professor Ellington indicated, to strike down barriers against full participation in our society, principally barriers against Black people, but also women and young people, and especially college students, through the exercise of the power to vote. It has been a bloody battle. This is not just a story about legal victories, one on top of another. Black people were lynched and killed if they tried to vote, or even if they tried to register to vote. Women got the right to vote, but only after decades of protests, being jailed, hunger strikes, and even brutal forced feeding while in jail. One important message that I want to convey, especially to the young people who are participating in this event, is the appreciation of the fact that college students changed America through the civil rights movement of the 1960s. Starting with the lunch counter sit-ins in Greensboro, North Carolina in 1960, to the freedom rides throughout the South to test desegregation of interstate travel in 1961, to Freedom Summer in 1964, when college students from all over the country went to Mississippi to help register people, to 1965 and the movement that was largely focused around Selma, Alabama, and the March for the Voting Rights Act in 1965. As John Davis said in the introduction, my work on voting rights takes place in this context. It spans more than 50 years from the time I spent in Selma in 1965 as a college student, helping the campaign for the passage of the Voting Rights Act while serving as an assistant to Dr. King's chief aide, the Reverend Andrew Young. 53 years later, after numerous voting rights battles through 4 decades of work with the ACLU in both Michigan and Florida, I was executive director of the ACLU of Florida, immersed in the campaign to end the largest voter suppression measure in the country, and drafting the constitutional amendment to end Florida's Civil War era felon disfranchisement system, and funding the campaign to change our Constitution. So there are so many examples of voter suppression. Opponents of voting rights, I have to say, never tire of inventing new ways to suppress or discourage the right to vote. We can talk about that for hours, but I just tried to put them into 4 categories. There are policies that erect barriers to voting itself. And the best example of that is Florida's lifetime voting ban. But there's also the use of a phony write-in candidate in which somebody throws in their name as a write-in candidate, which closes an election when only one party has fielded candidates in a primary. There are voter ID requirements that require things like an original birth certificate or a state-issued form. There are restrictions on voter registration drives or barriers to registering people on election day, and restrictions on where college students are permitted to vote, at home or in the town where they go to college. There are policies that dilute the power of the vote. The best example of that, of course, is gerrymandering, but also the battle that's going on now about trying to avoid a census undercount also dilutes the power of a vote. There are policies that put the thumb on the scale. Florida has a statute that requires that the order of candidates appearing on the ballot depends upon the political party of the governor in office, even though there is a statistical benefit to being listed first on the ballot. The placement of first on the ballot goes to the political party of the incumbent governor. And lastly, there are votes that are lost due to the maladministration of voting systems, bad ballot design, or the malfunctioning or insufficient number of voting machines. So I want to say, why is this all happening? Our country right now is dramatically polarized. Perhaps, as many people have commented, more so than any time since the Civil War. And there are demographic changes taking place. The electorate is becoming younger and more diverse. With more immigration, there will be more new Americans. Power is slipping away. After the Supreme Court gutted the Voting Rights Act, in the case that Professor Ellington mentioned, and from Shelby County, Alabama, many state legislatures rushed to adopt provisions that allowed them to manipulate the rules governing elections in order to suppress especially disfavored groups and especially racial minorities, and engage in partisan gerrymandering, all in order to hold on to power. If you want to remember one recent dramatic, horrible example, do you remember this picture of all the people in Wisconsin during the Wisconsin primary earlier in this year, where the Wisconsin legislature and the state and the federal courts forced people to risk their health and their lives in order to vote in the primary. Namely, they did not allow an extension of vote by mail. They had to vote in person, all to try to reduce turnout, and again, all to hold on to political power. I want to drill down a little bit on one particular measure, because it is the largest voter suppression measure in the country. It's ours from the state of Florida, and it is the most significant one, and it's the one in which there's still a fight about right now, and that's Florida's lifetime felon voting ban. As I mentioned, it is the largest voter suppression measure in the country by the number of people affected. 1.4 million is the best estimate of the number of people in Florida who are citizens but blocked from voting because of this ban. This was 10% of the total number of registered voters. Imagine that, 1 out of every 10 people in the state of Florida were blocked from voting. 23% of the voting age population of Black voters were disfranchised. Almost a quarter of every Black adult was unable to vote in Florida. And it was a lifetime voting ban. You could only get your right to vote back by the clemency process of the governor. It has its origin after the Civil War, as Professor Ellington described, in the 1868 Black Codes that were all designed to take the power of the vote away from the freed slaves. So I and other working, obviously not alone, but with a lot of other people, worked for about 18 years on shaping a possible constitutional amendment to end Florida's lifetime voting ban. And we got it on the ballot in November 2018. It was approved by about 2/3 of the voters. It was an impressive, multiracial, nonpartisan movement. The right to vote was restored, except for those who were convicted of murder or a felony sex offense, upon completion of the terms of a sentence. We wrote nothing in the proposed constitutional amendment about the obligation to pay fines, fees, or restitution, what are called legal financial obligation. A few months later, the legislature met and passed Senate Bill 7066, claiming that they were faithfully implementing Amendment 4. There's a lot of legal gobbledygook. I'm just going to give you the highlights here. What the legislature did, the primary change that the legislature made was that they put in place a requirement that a person would have to pay all legal financial obligations before they were able to vote. All fees, costs, fines, and restitution. But there was no system in place. There still is no system in place to let people know whether they owe any money, and if so, how much. That information exists in about 11 different databases that came out at trial. And the second and most significant thing that the legislature did was that it said that even if your debt was converted to a civil lien, you are still not eligible to vote if you have not paid off every penny. Now, you need to know that it's typical in the Florida criminal justice system that people who are determined to be indigent and unable to pay their fees, costs, fines, and restitution have that debt sold to a private debt collection agency, which then takes about 40% of whatever it is that you pay and reports the remaining 60% to the state as payment. And what the legislature did is to say that, well, if your fine has been converted to a civil lien and it's not fully paid, you still cannot vote. This was challenged in federal court by a coalition of voting rights organizations. And on Sunday, May 24th, Federal District Judge Robert Hinkle issued a 125-page opinion that I want to urge everybody to read. It is an important document on the history of the right to vote in Florida. The court's decision was a rebuke to the governor and the legislature. He said Florida has a pay-to-vote system that is unconstitutional, especially when applied to people who are unable to vote. Amendment 4, he said, expanded the electorate. The legislature, through Senate Bill 7066, limited that expansion. There are two essential elements of the court's ruling that I just want to mention, and one is wealth discrimination. The judge ruled that the state can condition the right to vote on the payment of fines and restitution that a person can pay, but the state cannot condition voting rights on the payment of an amount a person is genuinely unable to pay. That is, if fines and fees or restitution are owed and the person is convicted of a felony, that person is required to pay that, but the right to vote can't be conditioned on the payment of outstanding LFOs. The second thing that the court did that was very significant was that the court determined that a lot of these fees and costs have nothing to do with punishment. They are essentially taxes paid by everybody to sustain the criminal justice system. They have nothing to do with punishment. A person who is convicted of a minor felony pays the same amount as a person convicted of a very serious felony. They are a tax to support the criminal justice system, to support the court system, and because they are a tax, they are a violation of the 24th Amendment, that it prohibits barring people from voting if they have not paid a poll tax or any other tax as a condition in voting. Now, here's the bad news. And I have to say, it's not really the bad news. It's more like, at least for me, devastating news. The governor appealed to the 11th Circuit Court of Appeals, which in a 6-4 ruling en banc, that is by all of the sitting judges, reversed the federal court's decision and upheld the statute enacted by the legislature to restrict Amendment 4. That means that about 3/4 of all of those people who could have been eligible to vote this year by Amendment 4, approximately 750,000 people, 750,000, were blocked from voting in this election. The 11th Circuit decision included 2 judges that Governor DeSantis appointed to the Florida Supreme Court, that President Trump immediately appointed to the 11th Circuit Court of Appeals. These 2 judges had promised the Senate Judiciary Committee to recuse themselves from cases that had been heard by the Florida Supreme Court, but they did not. And they cast, in fact, they cast the deciding votes to overturn the federal district court and uphold the legislature's interpretation of Amendment 4. So I want to say that leaving us with this injustice that allows discrimination on the basis of wealth. Rich felons can vote, indigent felons cannot vote. And it leaves us with the absurd situation that individuals have an obligation to pay their legal financial obligations, but the state has no obligation to tell them how much they owe. I find that personally so offensive. Nevertheless, this battle is not over, and I do think that Amendment 4 will have a transformative effect on Florida and on Florida politics. Amendment 4 ended the Civil War era lifetime voting ban. It largely eliminated the role of the governor and the cabinet sitting as the board of executive clemency. And any person with a past felony conviction, except for murder or a felony sex offense, who does not have any outstanding legal financial obligations, can register and vote in this election. So let me conclude here by just a couple of things that I want to urge everybody here to do, to get involved in defending our democracy. I want to urge you to get involved. You can become a poll worker in the county of your residence. It's a paid position with the supervisor of elections. I want to urge you to be attentive to voter suppression tactics and help protect the right to vote. There's likely to be a good deal of chaos at the polls, especially in the battleground states. I want to urge you to help in the movement that must continue to end Florida's unjust pay-to-vote system. And I want to urge that you be inspired by all the people that came before you. Voting rights is the most important civil rights issue in Florida. It's the unfinished business of the civil rights movement. And you should be, I think, inspired by the students who went to Mississippi, some of whom were murdered. A student from my college was murdered in 1964. I want you to be inspired by former Congressman John Lewis, who at a very young age had the courage to stand up to Alabama state troopers, to be inspired by Black Floridians who stood in line in 2012 until midnight and were not deterred and wanted to cast their vote. and by those courageous people who voted in the Wisconsin primary earlier this year. Pick a voting reform, whatever it might be, that will expand the electorate. There are a lot of examples that we could talk about later. Pick a voting reform and work for it. Thank you.
Howard, Simon, thanks so much for your words and for all the work that you've been doing and continue to do. I'm now going to turn the floor over to our third and final speaker for this evening before we open up the Q&A. Jennifer Scuteri, the floor is yours.
Thank you. And I'm going to be a little bit shorter because this has all been a lot to absorb. Ron and Howard, great jobs. And if I were to say, you know, Ron kind of started with the national field of voter protection and voter rights, and Howard narrowed it to kind of statewide. And I'm going to say I'm the boots on the ground person. So I'm heavily involved in voter protection. And where better than Florida, the swingiest of the swing states, to talk about the right to vote and the right, how it comes under attack. Sometimes it's in unintended ways, sometimes maybe it's intended. So let's talk about what's going on in Florida right now. Well, we're, you know, a few weeks out now from an election. Early voting will start next week. Vote by mail has already started, and the last day to register to vote was supposed to be on Monday. So we were running around trying to get as many people registered to vote as possible, and focused in on all the different counties. And in Duval County, which is Jacksonville, we learned that over the prior 24 months, that the supervisor of elections had rejected 7,000 voter registration applications. That was almost double the size of counties that are the size of Duval County. Then we dug a little deeper. And of those 7,000 voter registration applications that were denied, 48% were African Americans. So you ask, intended or unintended? The supervisor of election said, you know, they made mistakes on their applications, but he's clearly an outlier. But what happens in Florida is what's called an exact match voter registration application. So one's name on their voter registration has to exactly match their name with their Social Security Administration. So those people that have the more complicated names that a clerk in the supervisor of elections office could easily misspell, not hyphenate, are going to be, their voter registration applications are going to be denied. And what people tend to have the more complicated spelling of names or hyphenated names, it's people of color. And so what we're seeing across the state is a much higher percentage of people of color that attempt to register to vote and their applications are denied. We also saw it in Orange County and Osceola County. A lot of the displaced Puerto Ricans that moved here after Hurricane Maria, they had their voter registration applications denied. They have complicated names. So, you know, one way to get around this would be for people to register to vote online. Then they get to actually input their name themselves. They can make sure it's spelled correctly, that it agrees with the Social Security Administration. But it goes exactly to what Howard just pointed out. So not only are Florida's exact match laws lean towards people being approved that have the more simpler names, registering to vote online, what does it require? It requires a computer. It requires a smartphone. It requires a certain level of education, which tends to work against people of color or people that are of lower income. So we see right at the outset in Florida, even gaining the right to vote is more difficult if you are a person of color or of lower income. Then we also have restricted access to vote. So what we see is where the supervisors of elections choose to have polling sites. And they often close the polling sites at universities and in low-income areas. And their argument is that the turnout's lower. But is that really the proper criteria? Shouldn't the proper criteria be that an early voting site should be located where people are less likely to have automobiles or affordable transportation to go to another polling site? So we were proud here in Lee County. They had closed the early voting site in Dunbar, which is an African-American community. They closed it before the 2018 election. Well, we got it back open. So, so people that live there and want to vote in their neighborhood and don't have to take 2 buses to get to the next nearest early voting site are now going to have a early voting site in their community. So we consider that a good win. Also, there just always seems to be things that go wrong. So Monday was the last day to register to vote in Florida. And we had a real surge of people going to the polls or trying to register to vote online in Florida. And what happened? The state voter registration system crashed. You know, they say something about it wasn't wired properly, it wasn't plugged in correctly. And then the next day they said, okay, we'll give you until 7:00 p.m. to register to vote. But kind of all that momentum that had been created and energy towards people registering to vote so they could cast their first vote in this election coming up kind of went out the door. And, you know, so these things happen and you always have to say intended or unintended. And then there's just kind of little twists, things that might happen, and Howard kind of put you on the alert. But a police car running outside a polling site, you know, if somebody's walking up to the polls and maybe they are a returning citizen, a felon that has paid their fines, you know, they might turn around. They might say, you know, it's not worth it for me to risk being arrested again. So, or having people inside or, you know, even or outside the polls threatening to make it difficult to approach the polls. So I'm just going to reiterate what Howard was saying is, you know, so what can you do to get involved is, you know, first off, make sure you vote. And he had talked about signing up as a poll watcher. That's, there is some risk because of COVID, but younger people are healthier. So you would, and, you know, I should answer, what does a poll watcher do? A poll watcher sits inside the poll and kind of makes sure nothing's going wrong. And one common thing that we might see happen in Florida, it's called the illegal assisted voter. And that's when, and you know, this is typically how it would occur. A husband and wife go in to vote and the husband kind of pokes over just to make sure how the wife is voting. You know, that's generalizing, but that is the common way that we might see it, that somebody is trying to, and it's illegal to influence how somebody votes at the polls. And then we also have, because Florida is such a large vote by mail state, you have a lot of problems with those vote by mail ballots. People forget to sign, their signature doesn't match their signature on file. They get it in the mail too late. But we do have an opportunity in Florida to cure some of these errors. And that would be something great for young people to get involved in, because it's a little bit complicated. It requires some people to print out what's called a cure affidavit and then make a photocopy of their ID. And there's plenty of voters we're reaching out to that could use some help. You know, somebody that could, you know, stand out in a safe distance at their home, but with their phone, take a picture of their ID and help them get their ballots cured. So like Howard, reaching out to you guys, you're a really powerful community, and I think you can make a real difference in your local community and in the state of Florida. So thank you for attending.
All right, thank you for that, Jennifer.
Okay.
Kinsey?
Hello, hello. So we've got a couple of questions from our chat box. We've got one from Madeline Stewart. Can Professor Ellington talk a bit about gerrymandering and why it is such a voter suppression measure?
Yes. Gerrymandering actually the name comes from Elbridge Gerry, who was one of the signers of the Declaration of Independence, but who, when he was the governor of Massachusetts, drew boundary lines for senatorial districts that would favor his party at the expense of the other party. Gerrymandering means that boundary lines are adjusted so that it favors one party over the other. Well, this has been going on as long as the country has been established, see Eldridge Gerry. But it's gotten far worse because of computers and big data. Now, legislative committees can draw boundary lines with almost surgical precision to ensure that voters of their persuasion would be a majority in most of the districts. One of the cases that went to the Supreme Court this past year was from North Carolina. Well, there are 13 congressional districts, and the Republican-led districting committee managed to draw the boundary lines so that 10 of those districts would elect Republicans, even though the division between Democrats and Republicans in the state was almost even on a statewide basis. So gerrymandering doesn't prevent someone from voting, but it has the effect of diluting the weight of that vote. And that's why it is antithetical to democracy. In a democracy, voters should be able to choose their representatives. With gerrymandering, representatives literally are able to choose their voters.
Thank you. Thank you so much for that. We have another question. This is from Palace Diaz. I just spoke with a voter yesterday whose husband is an ex-felon. She told me he very much wants to vote, and as far as they know, his fines have been paid. They don't know whether or not he'll be allowed to vote in 2020. Can someone please advise us as to where we should direct folks for help in these kinds of situations?
Well, let me say, this may sound like a stupid question first, but first of all, is the person registered? If they're not registered, then I mean, registration is the main barrier to voting. And one of the things we could talk about eventually is, why do we have a system in Florida where you have to register 29 days before the election? There are almost 24 states where you could register up to and on the day of the election. But in any case, if the person is not registered, it may be too late, although there's litigation going on right now about extending the voter registration deadline, and that issue is not yet resolved. So first of all, they have to be registered. Second of all, if the person sincerely believes that they have no outstanding legal financial obligations, they have the right to vote. I want to go back, if I can, just to the previous question and about Ron's description about gerrymandering. I do want to alert people at this Zoom meeting that once this presidential election is over, what Ron was talking about is the next big battle, because we are in the middle of a census, and the census is done every 10 years. And once this census is done, the legislature is going to have to get about the business of redistricting all of the state legislative districts and the congressional districts. And then we will be in a big battle about whether or not they are drawing those districts to favor an incumbent candidate or a political party. So that's the next big battle coming, probably 2022, 2021, 2022.
Wow, thank you, Howard. We appreciate that. That's a lot to think about. So we've got another question from Juanica McFarlane. Is it possible to retire as a state employee and still be a poll worker?
Oh, you'd have, I don't know, the person who would determine that is the supervisor of elections, but I don't see any, I mean, they take everybody. They're all filled up for this election cycle, but generally they would take everybody. So I would urge whoever asked that question to try to sign up as soon as this election is over. They're always looking for, I call them volunteers. They're not really volunteers because you get paid.
Yeah. I would just add that there's poll workers, and those are the ones that get paid. And then there's poll watchers, and those are people that are there representing one political party or another. So you don't get paid as a poll watcher, you're a volunteer, but probably both parties are looking for poll watchers. So I think there would still be the opportunity to serve in that capacity.
Just looking through the chat here, I think that about does it for questions. It looks like we have about 5 minutes left. So John, if you have any other discussion questions you'd like to pose, I'll turn it back over to you.
Thanks a lot, Kinsey. A question I wanted to pose to our panelists pertains to something that's going to be on the ballot here in Florida, November 3rd, and that is Amendment 1, which proposes to modify the Constitution here in Florida so that only U.S. citizens could vote in elections here. Kind of a head scratcher because I kind of thought that was the case now. Jennifer, can you provide us some insight on that?
So I don't have the exact language, and maybe somebody can pull it up what it currently says, but it currently says you have to be a U.S. citizen, you have to be a resident of Florida to register to vote in Florida. And the First Amendment really just kind of changes the order of that wording. And I think, you know, we talk about intended and unintended purposes. And I think to a lot of voters that are not informed, they're going to read that and think that people that are not US citizens up until this vote have been allowed to vote in Florida, which is not the case. So, you know, I don't really know the purpose of it. Yeah, it cleans up the wording maybe a little bit, but I wish there was an explanation, certainly in the amendment, talking about the fact that never has anyone been able to vote in Florida if they were not a US citizen.
John, I'd like to add something about that. You know, I don't think it does anything, and which is why almost everybody that I know, when I've read about, opposes it. It really does nothing. It changes things from every citizen is entitled to vote to only citizens entitled to vote. I don't know that makes any difference whatsoever. What I think is the real scandal about this is not only why is this piece of garbage put on the ballot to amend our Constitution, but the real scandal about this is that a change in our Constitution is put before the voters, and we have no idea why or who's funding it. That it's all put on there by a secret organization and by secret donors, and for that reason alone, I'm outraged by it.
On that note, there is a reporter on my team who is currently following that money trail. So stay tuned. Hopefully we'll come up with something there. In the spirit of disinformation, I know we hear a lot from the president about the problems and the threat of voter fraud. I was hoping, one or more members of our panel could maybe talk to us and maybe inject a little reality into that conversation.
Well, let's see. There are examples of voter fraud that have taken place, but all the studies that have been done have indicated that the number, I don't have it in front of me, but I forgot what it was, like 32 cases over the last 10 years or something like that. Nothing that has had the effect of threatening to change the outcome of an election. I think it's nonsense about, the president started with a crusade against mail voting. And one of the reasons that makes his analysis so wrong is that there are already 5 states that for almost a decade now engage in elections entirely by mail voting with virtually no problems whatsoever. So, I have to tell you that this may border on maybe too partisan a notion, but I think the complaint about voter fraud is really a complaint about too many people maybe voting. And if too many people vote, our chances of one side's chances of winning goes down. So, I don't know what the president's complaint is because he has changed it. He said voting by mail is no good. Oh, but except in Florida. Florida's got it done right. Then he was informed that for the last 20 years in Florida, absentee balloting has been dominated by Republicans. And so then he was told that he's endangering the turnout by senior citizens who vote disproportionately by mail ballot. So he's changed his tune so many times. I think the only thing that it comes down to that he's really opposed to is the sending out of unsolicited vote by mail applications or the actual ballots themselves to every eligible citizen. But I'm all about trying to increase turnout, and he's not.
I would add on to what Howard said is, because I am boots on the ground and looking at the ballots and what's happening and where errors are made. And I think that things happen and people immediately jump to voter fraud. Like I had one of my callers trying to call one of these people that was denied being able to register to vote, and the person had passed away. And the person that answered the phone started screaming at her that she was trying to register a dead person to vote. And she had no idea the person was dying. She wasn't trying to register a dead person to vote. Or there's issues with the voter by mail ballots. One of the most common errors is it's called the kind of crisscross signatures. and a husband signs a wife's envelope and the wife signs the husband's. And they're signing their own name, but their ballot inside doesn't agree with it. And the supervisor of elections just waits until he gets both sides and then he cures it. But they're not trying to commit voter fraud. It's just, it's just a mistake. There's no intention of committing voter fraud. And then we've had a couple ballots come in and the envelope has to be signed on the back. Well, sometimes they go through the post office upside down, and the post office, sometimes their mark is right over the signature. So now, and it's not common, but there's some ballots that the supervisors of elections are saying, we can't see your signature. And, so people are screaming, oh, it's voter fraud. But it's not voter fraud. It was just an innocent mistake by the post office, or that you can't trust the post office. So I think that people are very hypersensitive to anything that looks a little bit different. But certainly in Florida, it's kind of difficult to vote by mail, and there's going to be mistakes, but that doesn't mean it's voter fraud.
All right, thank you for that. And this is going to conclude tonight's virtual meeting on the right to vote. And I want to thank our featured speakers one more time, Ron Ellington, Howard Simon, and Jennifer Scuteri. Thank you so much for sharing your insights and your expertise with us. And
Thank you, John.
Before we go, I want to remind everybody about another special event the FGCU University Archives and Special Collections is putting on in conjunction with the current virtual exhibition, Fight for the Ballot, Voting Rights in the 20th Century. This one's titled Voices for Women's Suffrage. It's on October 28th, and it's a dramatic reading that brings to life the struggles and challenges that the heroes of the women's movement faced. And then after the reading, there's going to be a Q&A session featuring FGCU Professor of History, Dr. Frances Davey, and Sanibel League of Women Voters members, Madeline Stewart and Audria Anderson. Registration for that online event is required, and you can register using the link in the chat box now. Also, the FGCU University Archives and Special Collections has continued to provide digital exhibitions and events throughout the pandemic. But as anybody who is in the fundraising business knows, this is a terrible time to have to be fundraising. So if you did enjoy this event, if you were edified by it, please consider making a contribution to the archives, and you can do that using the link in your chat box now. Contributions from patrons like you are truly what ensure that archives can continue to pursue their mission of acquiring and preserving and providing public access to original primary source materials. And as we say in the public radio business, content worth listening to and engaging with is content that is worth your financial support. Thank you everybody for participating. Have a great evening. And for God's sake, if you're eligible and registered, vote. Thank you everybody.
All right, thank you.